The first attribution model that allows you to accurately measure when a viewer sees your ad on TV and the actions they take afterward, from site visits to conversions. Here's how it works. A viewer sees your mounting commercial. We note their IP address, device IDs, and additional signals, then identify all devices tied to that household. If the viewer visits your site on one of those devices, within a time window that you define, that's a verified visit. When the viewer converts on your site using one of those devices, we can attribute that outcome to your CTV campaign.
Reynolds Company, MNTN Incorporated, pronounced Mountain, is now facing a major lawsuit. You may remember this company as the one involved in legal trouble before, specifically when Mr. Valdoni sued Maximum Effort, a company tied to Reynolds. That case was dismissed, but the company tried to distance Reynolds a bit while still keeping him on their board. It looked like they were trying to protect themselves from legal damage back then. Now, they're in another, much more serious lawsuit, this time over patent infringement. A company called Intent IQ has filed the lawsuit. Intent IQ owns 80 patents related to online advertising technology. They've been suing large tech companies such as Amazon, Microsoft, Meta, LinkedIn, Roku, and others for using their patented technology without permission. In some of these cases, they've won huge settlements, $122 million from Amazon for example. Other companies like Meta and Roku chose to license the patents, paying Intent IQ to use their technology legally. The core of the issue is a specific patent owned by Intent IQ. This patent covers how advertisers track users' IP addresses and online behavior, which is vital to how online ads work today. MNTN Incorporated claims that they developed a new, innovative way to track ads across devices. However, Intent IQ says that's not true. They argue that MNTN is using their technology without permission and calling it their own. According to the lawsuit, MNTN is knowingly using this patented technology for tools like TV ad targeting, analytics, audience tracking, and data APIs. Intent IQ claims this is willful infringement, meaning MNTN is aware of the patent but continues using it anyway. The suit says that MNTN's entire business model depends on this tech. If the court rules against them and an injunction is granted, the company could be forced to shut down these services, possibly destroying the business altogether. What makes this even more serious is the timing. Intent IQ filed the lawsuit on May 23 RD, just one day after MNTN went public on the stock market. Yet, MNTN didn't mention the lawsuit in their earnings report, which they are required to do by law if a lawsuit could affect more than 10% of their revenue or assets. Intent IQ provided side-by-side comparisons of their patent details and MNTN's marketing materials, claiming they are nearly word-for-word identical. They're asking the court to stop MNTN from using this technology, to pay damages, and to cover court fees, interest, and all related expenses. This isn't MNTN's first brush with intellectual property issues. They've settled cases before. But this lawsuit is on a much larger scale. If Intent IQ wins, it could force MNTN to stop selling or using their main product, essentially crippling the company. The case is ongoing, but it's clear that this could change the future of MNTN, Reynolds' involvement, and how companies handle ad tech patents. Intent IQ has asked the court to officially declare this case as serious under U.S. law, specifically 35 U.S.C. 285, and they want to be paid back for their legal fees. They've also asked for a jury trial. So far, Intent IQ has been very successful in lawsuits like this one. They own a set of very important patents related to online advertising, and many big companies have already been forced to settle or license their technology. Reynolds Company, MNTN, Mountain, is currently under fire because they are claiming to have developed a unique advertising technology, something Intent IQ says they actually invented and patented long ago. The biggest concern? Mountain never told its investors about the lawsuit, even though it could seriously affect their future. They recently filed their Q2 earnings report and didn't include a single mention of this ongoing legal issue, which raises red flags. Intent IQ's lawsuit includes a detailed comparison between their original patent language and Mountain's product descriptions. And it's hard to ignore how similar the wording is. For instance, Intent IQ's patent describes a method using a computer system to track and link devices through network connections. Mountain's materials describe almost the exact same thing, line by line, but add some small details and examples to make it seem like their own invention. This pattern continues across several parts of the patent. Mountain appears to have simply taken the technical foundation that Intent IQ built and added a few twists to present it as something new. Intent IQ argues that these changes are not enough to make it original, it's still their invention. And they believe Mountain knew about the patent and copied it anyway. That's why the case alleges willful infringement, meaning they intentionally used the technology without permission. Intent IQ even sent warnings to Mountain in May, letting them know that they were violating the patent. In most cases, companies are given a chance to resolve the issue before going to court. But Mountain didn't take action. They even brought in new lawyers and requested more time to respond, which they've been granted, but they're still actively using and promoting the disputed technology. Some companies like Meta are trying to argue that the processes Intent IQ patented are too basic or too common in the tech industry to be protected by a patent. They call these obvious methods that anyone in the field would use. But legally, many courts have sided with Intent IQ, saying the patents are valid. Mountain markets their system as a revolutionary technology that helps advertisers track campaign results and find the right audiences through TV and digital platforms. They say they offer something other companies can't. But if the court rules in favor of Intent IQ, Mountain could be banned from using this entire system. The impact could be huge. Their entire business model, especially tools like audience targeting, performance tracking, and campaign data, depends on this technology. And Ryan Reynolds is clearly involved in the company's leadership. He's listed as the chief creative officer, right next to senior executives. This lawsuit could not only damage the company financially but also damage its credibility with investors and customers. If they lose, they might have to stop using their core technology, stop marketing it, and pay large damages, possibly ending their ability to operate as they do today. This situation could seriously impact Mountain's operations. If the court rules against them, they may have to completely stop using key parts of their platform, including audience targeting, TV performance tracking, verified visits, and API integration. All of these features are being marketed as if Mountain created them from scratch, which makes the whole case even more serious. They're promoting this system as something original, something that they invented, when according to the lawsuit, it actually belongs to someone else. If the claims are true, it raises a big question: how did the people in charge not know this? You would expect a professional company, especially one going public, to double-check their technology to make sure they aren't using someone else's work. But based on what's been presented, Mountain may have built their entire advertising model on something they don't legally own. And that could lead to either having to pay a licensing fee or be forced to shut it down entirely. What makes this more controversial is Ryan Reynolds' involvement. He's not just a face for the brand, he's part of the senior leadership. And this isn't the first time his name has been linked to intellectual property issues. There were earlier accusations that he stole creative ideas, like the Deadpool movie concept from director Tim Miller, and claims that he and his wife Blake Lively tried to take over the film rights to It Ends With Us from Justin Baldoni. Even Mint Mobile, another company connected to Ryan, has faced lawsuits, including a class action case for allegedly recording phone calls without consent and previous claims related to how its network was designed. So this Mountain lawsuit is not happening in isolation. It seems to follow a pattern where businesses linked to Ryan face repeated claims of using others' work without permission. If this case goes to trial and Mountain doesn't settle or get a license, the outcome could force them to rebuild their entire marketing tech. The systems they're using to measure ad performance, connect campaigns to purchases, and report results would have to be completely replaced, a huge setback for the company. The bigger issue here is trust. The lawsuit claims that nothing Mountain offers is truly original. If true, it means they've been selling borrowed ideas as if they were their own, which could hurt not only their business but their reputation as well. Customers and investors were led to believe they were getting access to cutting-edge tools, but it turns out it may have all come from someone else's blueprint. We'll have to wait and see how Mountain responds, but based on what's happened with other companies sued by IntentIQ, the outcome may not be favorable. Let me know what you think in the comments, give this video a like, don't forget to subscribe, and tap the bell so you're updated whenever a new video drops. Thanks for tuning in. If you enjoyed this video, don't forget to hit the like button, follow for more updates, and subscribe to the channel. Your support keeps us going.